The inaugural First Nations president of the National Native Title Tribunal, but over 28 years of experience in First Nations and Native Title law, and has had several, kind of quite influential positions around the countryside, including being the CEO of CNTA. And when I first met Kevin, it actually was at one of these CNTA conferences. And I thought, oh, this is interesting. Okay, what's he going to talk about? And he got up with this sort of conceptual and theoretical framework of the whole of native title into the future. And I was just blown away because I thought I'd never heard any CEO of any organisation get up and present a conceptual and theoretical framework, the big picture kind of thinking and strategising. And that, I think, is what Kevin does brilliantly. A canny strategist and a very sort of visionary thinker with ideas that can help progress things. So would you join with me in welcoming Kevin?
Firstly, I want to acknowledge country, acknowledge the Yagara and Turrbal peoples on the land on which we're meeting today, and pay respects to elders past and present. Also want to acknowledge Aboriginal and Torres Strait Islander people in the audience, as well as online. Thank you, Di, for that very flattering, although it may be a bit slightly inaccurate description. But I'm going to probably continue with the theme of conceptual thinking in this forum, because I think this particular forum lends itself to that type of thinking. And I was thinking about that conversation that we finished yesterday around the benefit of these particular forums. I know that my former colleague, Carmen from CNTA, will be talking about people, place and partnership. And it was actually, I conceived that idea for Queensland South Native Title Services as a result of coming to one of these meetings about 7 or 8 years ago, listening to the CLC talking about community development. So this space is an innovative space, and that's why it's an important space to come together and talk about things. So my topic, as it says up there, is around preservation of cultural knowledge. It is a challenge that has been bubbling along in the system for a little while, but it's starting to come to the fore, because to pick up Lee Sackett's penchant for the word yesterday, transition, the system is transitioning, and we need to be able to look at those system challenges to as the system is transitioning, how are we dealing with those challenges into the future. So it's just to give you some context, and I want to thank yesterday's session presenters for contextualising the operating environment. But I do think it's necessary for me to just repeat some of the broader operating context that we're in, because it paints the challenge somewhat for what I'm going to be dealing with. So I often make the point when I speak at forums like this that we automatically think that we're moving into the post-determination context, and we are, and indeed that's the theme of today, to talk about anthropological contribution to a post-determination context. But I always like to just say, can people always remember where we are at the moment, and there is a lot of unfinished business in the claim space, in the NTDA space, the native title determination application space. And that is one of the factors that's really occupying a lot of people's attention. So how do we finalise this first phase of native title, the recognition phase? And the way I'm contextualising, and look, I probably should say, and there are many reasons for why claims may have been parked, for strategic reasons, forensic reasons. There may have been overlaps in the past, and it was best to just withdraw boundaries, focus on core country, get a determination, and leave the gap areas for another day. There was obviously, there are sea country claims, and we've got some maps. I've got a map. Wouldn't be the tribunal without a map, but the map depicts where the historical sea country claims are. It's stands to reason that people will want to consolidate all their country, land and sea, and at some point sea claims will need to be brought in the reckoning. And but I can say that the days of when we were filing claims in response to non-claimant applications or Future Act, there was a lot of claims being filed directly responsive to Future Act activity. I think that's slowed down somewhat, but obviously it's still a variable. But I think that we are moving into this next phase of consolidating the estate. And I use these terms standalone and consolidation because standalone, I'm using that as a definition for where there is a claim that does not have a contiguous determination. And over time, you will see that class of claim reduce, and you would see the increase of the consolidation claims come more to the fore. And consolidation claims is what it says. It's consolidating the Indigenous estate, and that means looking at the gap areas and the areas that were strategically parked. So I just wanted to paint that. There's an emerging area. Obviously, this is not a linear concept, but it would make sense that you would consolidate your estate and then move into the compensation phase. This is going to be one of the big drivers of where the work is going into the future, and there's no doubt about that. So at the moment, we've only got 6 compensation claims in the system, but we've had several claims come through, and they have been the result of either being dismissed or indeed an agreement has been struck. And but it's going to be this is the burgeoning area, and we've got to keep our eye focused on where the work is going. Variation applications, and we all know that determinations, although they are in rem, in perpetuity, last forever, but they can be subject to variation if the circumstances change. And the pace in which the first phase has been prosecuted, it stands to reason that there will be variation applications, and that they will come in due course. And indeed, with the 47C, where you can bring, you can make by agreement national parks and the like, you can have a determination over those areas. There's likely to be variations occurring consequent upon that. So there's going to be another area of work that will occur, but it's going to be, they're not knocking the door down, so to speak. This same phase, so again in this transition phase, people are busily implementing agreements that have been negotiated and struck over the past 30 odd years. And those figures there that I'm giving, so hopefully you can read it. So there's currently around 4,000 Section 31 agreements. And that's not to say that those agreements have not finalised, but my experience is that once the payments have been made under those Section 31 agreements, some of the agreements continue in a range of other ways. And so there could be a lot of work, a lot of agreements that are still subject to implementation. There are currently 15 odd ILUAs on the register that the tribunal holds, and I would say that there's a lot of work that still needs to be done in those ILUAs. A lot of those ILUAs were struck around the resolution of the claims and the rights that continue into the future, and there's still a lot of implementation work that needs to be done. There are lots of stats in this next slide, but all I'm trying to get at is that there is an interface with the Future Act regime. In fact, there is, people might be aware that the Australian Law Reform Commission is presently conducting an inquiry into the Future Act regime and indeed some of the practices of the tribunal, how we conduct, make some decisions in that regard. So this is a live area, and it's a really important area, and I would welcome people to look at the terms of reference of the inquiry and submit where you can. But I put these stats up there just to highlight the fact that there is a lot of work in the Future Act regime that's rarely seen by the court, but people that work in rep bodies, PBCs, this is a lot of work that just keeps coming. The Section 29 notices just keep coming through the door, and you need to contend with those. And people need to obviously, there's an expedited procedure, and when the native title party objects to the state asserting the expedited procedure, and that means that with an expedited procedure, the right to negotiate is not attracted. It just goes straight through, tick the box, and it can move forward. But if there's a successful objection to the expedited procedure, then obviously the RTN is activated. And just anecdotally, and we've put together some stats here, it goes to show that of say average 2,400 a year, about half of those will assert the expedited procedure, and then again there'll be another half where there are objections, but many of those objections will be withdrawn, or by agreement will be withdrawn, and there's a cultural heritage agreement that might be struck as a result of that. My concern is the numbers that are withdrawn because people don't have the capacity to engage in the process. And I just want to put that there and I think that there is a significant portion of that area of work that does not proceed because people simply don't have the resources. And when you can have all the rights recognised under the sun and you can't enjoy them because of capacity constraints, there's a problem with that. There's also many thousands of broader Section 24 notices. So, public, putting public facilities and the like. And I'm afraid that these are the notices that native title claimants as well as PBCs tend to park to one side because it's the maelstrom of work in these other areas that's occupying them. So even though you might have a right to comment, the right to receive a notice and the like, when you don't exercise those rights, these things just continue through. One benefit of this is that the right to compensation does continue. So even though you may have not availed yourself of a right to comment or to be consulted, if there is a compensable act, there will be compensation, the right to claim compensation at one point. And I want to look back into that because it brings us back to compensation. So you can see from over that really complex operating environment, people are being bombarded with work all over the place, and at some point compensation is going to have to be considered in the reckoning of all this. I think this is an area around governance that's really critical to the way that anthropologists work. So if we're the way I like thinking about governance is there's community governance, and then there's the organisational governance, so the institutions that support the community, and then there's the operational governance. And operational governance, I would characterise it at all the things above that line. It's obviously agreement making, it's implementing agreements, it's interaction with the cultural heritage regime, the Future Act regime and the like. And so there are these domains of governance, but all three of those domains are interrelated, and there is an intercultural overlay over all three of those areas. And I think in a post-determination context, anthropologists have a really important role to play in the relationship mapping about those different domains, how they relate to each other, and also the context of the intercultural overlay that it operates within. And that's really messy, and it needs people with skills like yourselves to actually help orientate and navigate that complex system. So in summary, when you look at that, there's a high volume of complex work. We have limited resources. There's stretched capability. So that's experts as well as PBC directors who are invariably volunteers. These people are volunteers having to do all of this work in that capacity. A lot of these things are time sensitive, and they're a time sensitive imperative. So the tribunal has time limitations and that people need to comply with, and so people are making decisions in that context. It puts people in a really uncomfortable place to do priority setting when you've got all these other things at play. And I have to say that all these regimes there's multiple regimes at play. So So there's obviously the Native Title Act, there's the PPC regulations, there's the Future Act regime and the like. So, and that's not to mention just business things like tax and the like. So there's all these multiple regimes at play. I'm just conscious of the time, but the map there speaks of where the determination. So that clay colour, if you like, is really where the determinations have been. So you can see that there's a critical mass. So almost 45% of the land mass of Australia has a positive determination over it. And where you see the red, that's where a native title has been found not to exist. But you can see that there's the Indigenous estate is growing, and it's growing significantly. And at some point in time, you can't probably make out, well, you can, the green colour picks up the consolidation claims. And so over time, you would see the gap areas, the green area will be the dominant colour where there are gap areas, and hopefully then standalone claims will be knocked over. What is interesting in this is where there's a number of PBCs that are there. So the number of PBCs at the moment, there's 285 PBCs. The ORIC figure might be slightly less than that because they go on a calendar year, on an annual year. A financial year, I meant to say. But yeah, 285 PBCs in the area. So there's a critical mass of PBCs that are operating. Now, all of that brings me to what the challenge is. So, this is all of that complexity I just outlined for you is the native title holders bear the burden of the system workload. You can see the common thread through all of those things. And I have to say that elders bear the knowledge burden to discharge the workload. And it's the knowledge that elders hold that it's used regularly to prosecute claims, to do a whole range of things. And I made my opening comments around the fact that the system has been raising the challenge around we're losing our old people at a rapid rate and how we are preserving evidence and preserving culture. And the next quote that I'm will give you, this might be triggering for some Aboriginal people and Torres Strait Islander people in the audience, but it just bears home the problem. And it's a quote that was uplifted from a case that's Justine Toohey. So Justine Toohey is the Principal Legal Officer of KLC, and who we all know. And it's in a recent case that was dealt with by Chief Justice Mortimer. And it's around this issue of preservation of evidence. But I think Justine's affidavit that's cited in the judgment really depicts the challenge, and it's a very human challenge that the system is facing. And I'll just read it if you can't see it from where you are. So Justine's been at KLC for some time, and so this is her quote, a large number of senior elders within the Kimberley have passed away, each of whom had significant knowledge about the impact of compensable acts. So this is to do specifically with compensable acts on native title rights and interests. In the past 5 years, I believe more than 20 very senior and elderly members of native title groups throughout the Kimberley have passed away. These elders were, to the best of my knowledge, in the age range of 70 to 90 years old. People with direct experiences of events in the 1970s are now at least 60 years old, but they are more likely to be in their 70s and 80s. And according to the Australian Institute of Health and Welfare, the average life expectancy of a First Nations male person in the Kimberley is 66 years old, and a First Nations female person in the Kimberley is 70.6 years old. So you can see, if we're thinking that the next phase of native title is all moving to compensation, and the best evidence that can be led to support a compensation claim will be the group of people who we are losing the fastest. And so we have to make a conscious effort about how we actually preserve that evidence. And this particular case highlighted that. The next point it talks about, so if that's a regional challenge, you replicate that across the 14 other rep body and service provider regions, you'll get a similar issue. And while this particular matter is just dealing with compensation and compensation over a special lease, so a very finite area within the Kurrajuri determination, you replicate that broadly across that claim area and then across the regions, you're looking at a lot of compensable acts and a lot of evidence from knowledge holders that will need to be preserved. And that's just painting the challenge. So the reality is that the way to deal with those system challenges is really there needs to be greater collaboration. And we see that within sectors. We see that in the rep body sector. We see that in professional sectors like anthropologists and lawyers. We see it within the context of claims, to how we innovatively resolve complex issues within a claim. But I think the challenge for the future and now is how the system together is working to resolve these big challenges. And I have to say that the Preservation of Evidence Working Group, and it's an initiative of the Attorney General's Department, but it has brought together a range of key, disparate parties. So we've got state and territory governments, we've got rep bodies, we've got some of the peak bodies involved, sitting down seriously trying to deal with this challenge. And it's good because we've acknowledged it's a system problem, system challenge, and it will have an impact into the future. But these are some of the things that the PEG is looking at. And I'll let you read those yourselves. But I suppose the third one is really what I'm interested in at the moment. And obviously the fourth one's important. That's the mischief we're trying to deal with. But it's to optimise the evidence gathered to serve multiple purposes. So claims. So go back to that operating environment where there's several claims yet to be resolved. They will be the complex ones. They're the gap area ones that have been parked for a reason. We will need to preserve evidence for that. We heard a lot about disputes within the governance context. There needs to be evidence preserved around membership to the group and recruitment to the group and the like. Compensation, we've just spoken about that. And PBC functions are also a cause. So a cause for the reason to preserve cultural knowledge. So all of these things are at play, but I think working together is really putting the spirit of the preamble in action, and that is to work collaboratively to try to sort out some of these issues. Now, so there are lots of obstacles, and I just want to whip through those very quickly. I'll just put them all up. Oh, gee, what have I done? There you go. So look, I think the PEG has been great. So you've got all these different views being expressed in this working group. But it's interesting as an observer to see that there is still the professional rigidity and risk aversion. So, and that's not being derogatory. That reflects institutions that have to keep separation of power at foremost in their mind. There's obviously lawyers have fiduciary duties, and when you have a fiduciary duty to a fiduciary, you tend to be really circumspect in how you make decisions. But and it's necessary. When you have a client that has to be a model litigant in the state and territory governments and the Commonwealth, there's a reason for why there might be risk aversion. But there are many obstacles, but the challenge needs to be overcome. Scale, resources, and capability. I think preserving evidence at the kind of scale that we're talking about, and if we're talking about people who are in their 60s, 70s, and 80s. And that's multiplied across the country, that's an enormous logistical task to try to address that issue. When I raised preservation of cultural knowledge at the no title forum of the court last week, I got I think the response from Wendy Ash was, we have to be careful about it. When you preserve cultural knowledge, is that freezing evidence in time or ossifying culture. And that's probably what I wasn't getting at, but I think that's actually a real perception that when you make attempts at preserving cultural knowledge, there may be perceptions of you are attempting to freeze it in time, and we need to be mindful of that. when you open these things up, it has the potential of starting a whole new range of disputes, and we've got to be careful of that. Litigation fatigue and trauma, that's something that's we all know about. 2 minutes, wow, okay, yeah, and that's clearly something that we've got to deal with. And there are a range of evidentiary challenges. So, preserving evidence in the absence of no pleadings, and what is the probative value of material that's obtained without cross-examination and the like. So there are real challenges to why people are reluctant to think innovatively about it. Now, there are a range of options, and Di's just given me 2 minutes. Now, I don't know how I'm going to get through this in 2 minutes, but the takeaway is doing nothing is not an option, because when you've got the knowledge holders that are going to substantiate the claims and the range of things into the future, there needs to be an innovative way of resolving this particular issue. Now, the Karajo case is, I'm not going to even have time to get into it, but that was a case that was handed down just last year where the Chief Justice actually said there wasn't a proceeding before the court, but the court had jurisdiction to take preservation evidence in anticipation of a compensation claim being filed. And that's actually a bit of a game changer, because if we talk about the sequential ways of doing things, you've got to file, authorise a claim, file it, and then prosecute it, and then you've got to get early evidence. This is actually a way of looking at it differently, and it just goes to show that the court is prepared to look at things differently. But whether that is a silver bullet, not one of these things are silver bullets. But I think the next 3 points are really critical ones. Leveraging the archive that's there at the moment, and this is actually an anthropological task. Auditing all the material from a whole of country perspective, consolidating it. I think we need to take statements and videotaping and doing a whole range of things. Yes, there may be risk about the probative value of it, but really, what is the option to that? You don't preserve the evidence, and then it's gone forever. I think mapping traditional knowledge is really, really important, and using modern technologies to do that. Look, I'll just cut to the chase that the tribunal is looking at how we might be able to use existing statutory tools, and there is a tool called Section 60 AAA, where it's a post-determination function where the PBC, common law holders and members, if there is to promote agreement among the group about a range of things. We've traditionally looked at that around dispute resolution, but the word promote agreement is something more than dispute resolution. It's around promoting agreement about a range of things. And I think how you might preserve your evidence, how you might plan for the gap area claims, how you might do PBC governance, they're things that are in the remit of promote agreement, and the tribunal is taking a very broad interpretation of that. That scheme, look, this presentation will go up to on the website, and you can obviously come and see me later. But it's a concept where the tribunal may be involved using its Section 60 AAA powers, using its ILUA assistance powers, but also its mapping and research assistance functions to try to assist RNTBCs navigate this complexity and preserve that cultural knowledge. And you might get an outcome, you might get a compensation ILUA, you might get a whole range of outcomes that'll be solidified in an ILUA, but it's all done in the confidential remit of the tribunal. So there you can manage risk a little bit by it's not going to be then leaked to the world at large. And then there can be a refining of matters, and clearly the federal court will need to deal with very specific applications. And that's how the two institutions might work better together with the challenge that's before it. And that hard red line down the middle is because there is clear demarcation between the tribunal and the federal court. Now, I just want to close with I'll put all these opportunities up because I think they're important. So as I just said, we've got a suite of statutory tools. There's a growing landmass of positive determinations, 45% of the landmass. That can only increase over time if all those in the consolidation of the Indigenous estate, if they convert to determinations. It's not fanciful to be thinking that we will have up to 55% of the landmass subject to a positive determination. in Australia. 80% of all determinations are done by consent, so there's already a culture of agreement making in the system, and it's leveraging on that. We need to leverage and utilise the extensive archive that we have. Reinventing wheels is a silly thing to do in this game, and obviously utilising using the archive is important. Interdisciplinary ways of working is critical. Preserving, protecting and promoting information is really important to native title decision making. But I'll just finish on that last point. Increasing the options to retain and transmit cultural knowledge to respond to the challenges of modernity, intergenerational change and diaspora is really a critical thing for this particular project. And I think I've finished at 9:30. There's no time for questions.
No, I've got 9:28 on my phone. And I know that Kevin was really specifically interested in some critique of what he's saying. So, if you want to ask some questions, I think he's interested in. So, big idea. How do you kind of deal with some of those risks and potentially move that idea forward?
We know there's a resource constraint. We know that there's professional constraints about how far we can go with these things. There's institutional constraints, but we have a real problem here, a real challenge. And I'm interested in your views about, how you might advance this. Thanks, Emily.
Thank you. Emily Sexton, PVC Link. My question goes exactly to resourcing, because we've talked about there being 285 PBCs in existence and their funding is extremely constrained. So this might be very useful in the determination and evidence gathering element, where we can access additional funding, take some extra days and gather this sort of information. But in the post-determination space, where I work with PVCs who, at the moment we're working on capturing this information to make it in formats that can be used in various operational aspects of PVC work. The access to funding it's not there. So we have to do it and gather that information in really, back of the envelope almost, and not with the depth that is required and needed and wanted by the community, but they just can't afford it. And we can't progress it, even though we might want to, and the PVCs want to.
Yeah.
So do you have any indication there?
Emily, so that this particular concept is premised that the crosses are operational funding and the double crosses are for project funding. We think we actually need to get proof of concept on this, so to get a pilot project up and running from various places around the country and actually use the model. And it goes back to my earlier point. If the system starts thinking of itself as a system and it's to be sustainable, then the system, and to pick up the point yesterday, we are all system advocates. Yes, we are experts and impartial in various roles, but everyone in this room and everyone out there that wants to be involved in native title needs to advocate strongly for a sustainable system. So resources are always a challenge in this area, but it's innovation, but it's also getting some pilot project money to actually get proof of concept. And I think that's probably the best way of dealing with that. But I think, there's an archive out there. Start preparing, start developing the archive, start utilising the archive. And rep bodies, I think, need to have an eye on interdisciplinary ways of working, so that we no longer do the work sequentially or linearly. It's actually, we've got a whole range of things at point, because old people don't want to be humbugged every time you want to come back to do a different function under the Act. We've got to be thinking more broadly about all those functions. So that's the only way to deal with the resource constraint, I think.
Thanks, Kevin. If you'll join with me, and I think we haven't got time.